Hello, everyone. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at I.S. law firm. Today's video is going to be dedicated, today's live stream is going to be dedicated to immigration into the United States through business, through investment and business ownership and business creation in the United States. Once I'm done with explaining the basic principles of business immigration through investment and business creation in the United States, then I will go ahead and answer as many questions as I can. The questions do not have to be necessarily related to this topic. It can be about anything else, any other immigration questions you may have. Please post your questions on the chat section. And I will try to answer as many questions as I can. Please also like and subscribe to our channel. Please like this video and subscribe to our channel. Okay, so what are the main methods of ways of immigrating into the United States through investment and business ownership? Many of you probably have heard of the process called EB5, investment, 1 million investment and 10 jobs creation, and then you can immigrate into the United States. But that's not the only method. And a lot of people cannot afford to invest this much. But there are other ways to immigrate into the US through creation and ownership and management of a small business in the US. The first thing to understand is that you do not have to be lawful, in a lawful status in the US to own and create a business. You do not have to have a work authorization to create and own business. You do not even have to be in the United States to create and own a business in the US. Anybody, anywhere in the world can create a business in the United States, and we can help you with that. And you can hire employees, you can have your business develop and bring you income. You will get a tax ID with which you will be able to file taxes in the US. But as I said again, you don't have to even be physically present in the US or have any kind of visa to the United States to own a business. So going back to the immigration, ways of immigrating into the United States through business, as I said, there are multiple ways. It's not only $1 million investment based green card. There are many other options. So what are those options? The first option that I would like to talk about is the E2 investor visa. This is an investor visa, is a visa based on the treaty between the United States and many other countries, based on which the owner of a small business can come to the United States with their family, live in the United States, own and manage their business. That's called E2 investor visa. So I see that more people are joining our live stream. Please like this video and subscribe to our channel, and please post your questions on the chat section after I'm done explaining the ways of immigrating into the United States through business ownership or through creating a business. I will also answer as many questions as I can. So the E2 visa allows the owner of a small business to enter the United States, to live in the United States, bring their family into the US, and the spouse of the E2 principal owner can also work anywhere else they want. In the past, they had to file for employment authorization document before being able to be employed in the US, but now they don't have to. They can actually work based on their E2 visa as a spouse of the principal owner. The children of the E2 visa holders can live in the United States as well, as long as they're under 21, and they can go to school, and they will be considered the residents for the school purposes. So they can go to public schools, which at no charge. So the requirements of E2 visa are that your country that you're citizen of must have a treaty with the United States. We'll post a link below with to the State Department's list of the countries that the United States has E2 treaty with. And it's most of the countries in the world, I should say. So if you see your country listed there, that means your country has E2 treaty with the United States, and you can be a candidate for E2 visa. So so that's number one requirement. Number two requirement, you have to create from scratch or buy an existing business, a small business in the US, and you have to invest substantial amount of money. Now, the substantial amount of investment is the catchword. There is no specific definition to it, but typically what we say is 100,000 or more is enough. Now, we have had many E2 visas approved based on investment of about 85, 75,000. The more, the better. But it doesn't have to be, several 100,000 or million or whatsoever. So the business has to be an active, at-risk business. What this means is that I'm often asked by potential clients whether they can buy a house and put it on rent, and that can serve as a business for E2. The answer is no, it cannot. So it has to be an active business, that you should have a business plan to progressively grow it, and it has to bring benefit to U.S. economy. So, for example, if you open a small pizza store or a beauty salon or a grocery store, convenience store, or you open a marketing company, IT company, whatever it might be, but it has to be a progressive business with employees, with investment, and it has to be at-risk business. So as long as that's the case, then you can qualify for E2 investment-based visa and bring your family. One of the challenging requirements for E2 visa is to demonstrate the source of funds. So, for example, if you spent 75,000 for your business, you bought equipment, you rented an office, you hired an employee, paid your lawyer, paid your accountant, and so on, and then you spent about 75,000 or so. Typically, we say at that point we can start applying for your visa for your family through consulate, or if you're in the United States, we can file for change of status. But one of the challenges that you have to demonstrate where you got that 75,000, where did it come from? And that's where there is a lot of misunderstanding. Sometimes we have clients who are applying for E2 visa, and when we get to the point of asking the source of funds, they say, well, we sold a house at one point, and then and we have documentation to show that we sold the house. That's where the money came from. But then they cannot demonstrate the trace of funds, meaning they cannot show that the money from the sale of the house went to a bank account, and then it was transferred from that bank account to another account, and then it ended up in the US through wire transfers. If you cannot show the trace of funds, then just showing that at one point you sold the house is not going to cut it. And the easy way to understand this is to understand that for E2 purposes, the United States is not concerned whether, where you could get that money from. They're not questioning your ability to earn that money or find that investment money, but they are questioning specifically the funds that you're going to use for E2. They're questioning the cleanliness of those funds, the legality of those funds. So you have to show how the money was passed on from account to account. Once it's converted to cash, it's almost impossible to ever demonstrate that this money are not, from smuggling or drug trafficking or money laundering. So this is, clean money that you earned or you got from sale of your assets. Sometimes people sell their cars. The cars nowadays, very expensive, and it may cover the entire amount of your investment for the E2 purposes. So E2 visa is very beneficial. It can give you, you can remain in the US indefinitely. You can renew it unlimited amount of times as long as your business continues and you're still managing your business, and as long as you're following through with your business plan. I'm often asked where to start with the E2 visa. I always say first decide where you're going to open your business, what you will do, and when you want to do it. So, and how you want to do it. So, when, what, where, and how are the important questions for you to answer yourself. And then you can start putting it together in the form of a formal business plan. And then the next step, when you're already starting the business, is to register a business entity in the United States, and we can help you with that. You don't have to be in the US. It's always helpful if you are in the US, or if you have somebody in the US who will be managing your corporation, your LLC in the beginning. So in that case, they can help you with navigating the initial steps. But in terms of legal work, we can register your corporate entity, your business entity, and you can own and register with IRS, get a tax ID, and you will have bank accounts where you can transfer the money and navigate your business. The next step after that will be, spending the amount of your investment for the business purposes. And then we work together with you to gather all of those documents and proof and evidence, invoices, vendor lists, employee records, and so on. We put it together in the package in the form of memo and exhibits, and we file it. Again, if you're in the US with the USCIS, if you're outside of the US, then we file it with the consulate. So that's the E2 process. That's investment in the small business. That's option one, to immigrate into the US through business, through entrepreneurial activities. The second option is, as many of you probably have heard, is EB5, which is investment of $1 million or more and creation of 10 jobs in the US through your business will give you permanent residency in the US. Will lead you to the permanent residency. It's not as fast and as simple as it may sound. It's a process. You would have to file the petition. You would have to spend substantial part of the amount, part of the funds, and you have to demonstrate that those funds are committed, that you cannot, just quickly sell everything and close after you become a permanent resident. And the permanent residency through this investment is limited to 2 years, and then you can renew the green card after 2 years. You have to demonstrate that you did everything you promised to create those 10 jobs and to spend the money that you promised to spend for your business purposes. So that's EB5, green card through business. Now, sometimes we have clients contacting us and telling us that they want to invest $1 million and they want to start this business, and then get permanent residency. We tell them start with E2. As long as your country has a treaty with the United States, start with E2 investment, small business, and then grow it into big one, and then you can try EB5 while you're in the US, while you're already settled here, so you're not in rush and your business is not suffering because of your absence. So the third option for investment-based immigration into the US is a visa called L1, L1A specifically. That's for the managers and executives of international companies. So it's also called intra-company transferee. So the L1 requires you to have a business abroad, and you have to have also business in the US. You have to register and create a business in the US. Those businesses don't have to be identical, but they have to be affiliated, meaning at least 50% of the ownership of those two businesses has to be common, meaning same ownership, same people or group of people own the 50% of one business and 50% of the other, or more, 50 or more. And so the requirement is that you, as the principal applicant, have to have been employed in the foreign business, foreign affiliate, for a period of 1 year or more in the last 3 years. And you have to have managerial duties or executive duties for the business in the United States. So as long as that's the case, you can apply for L1. Now, the challenges with L1 is that the business has to be developed enough to maintain you just as a manager or executive, meaning you should not be doing day-to-day simple, clerical work. And for that, if you're a manager or executive, the business probably has to have, a large number of employees. And by that, what I mean is, it's more than 5, 6. So, 6, 7, 8, 10 employees or more. And it has to be a very active, real business to be able to maintain your employment for that business as a manager or executive only. And L1s are very, deeply scrutinized, and they are often denied. We have, through American Immigration Lawyers Association, we have a message center where we share our experiences and frustrations sometimes with the USCIS. And we often, my colleagues and I, we share those requests for evidence or denials in L1A cases in small business settings. So, because the USCIS, many officers perceive L1 as only available for large businesses, large corporations that have multiple employees abroad, and they're now transferring their employees here into the US, and those are easier L1 cases. But in terms of L1s for small business, it's very challenging, very difficult. Now, again, going back to E2 investor visa, the treaty-based investor visa, what we usually recommend is for anybody who wants to try L1A, they can try E2 first, which is faster, easier, and none of it is guaranteed, but it's more likely. You have much higher chances of getting E2 investor visa approved, and then you can move into the US with your family. And once you're settled down here, you're already working for your business, you're developing it. As long as you have a foreign business, with somewhat similar type of operations, then you can try also L1A, because you had to leave that business, your position, you jump at that business to come and manage this business here, then you may qualify for L1A. But again, it doesn't hurt to try, but you can try. But the benefit is, at least you have E2, which gives you indefinite amount of time to remain in the US and to manage it. You have to extend E2 visas every 2 years. So in all aspects, among these three different options of business immigration through owning a business or creating a business in the US, in all aspects, E2 is the more preferred version. And if it's not, if you think you qualify for EB5 or L1, at least you can use E2 as a ramp to start, as a first step. You can easily come and bring your family, live here, and then you can try. Why many people prefer L1 over E2, meaning why do they try L1 after E2, is because there is a process called EB1C, which is for executives and managers of international companies, that they can apply for green card through this process. So L1A is sort of like a prelude to green card application, to permanent residency, and that's why many people try to apply for L1 versus E2. So these are the three bases of immigrating into the US on the basis of creating your own business and owning business. The fourth method is, it's not something that was devised by Congress. It's something that is devised by the executive order. I believe it started under Obama administration that talks about this, but I believe it started just about recently with the Biden administration under the executive order. I may be wrong. It's called International Entrepreneur Parole. So it's International Entrepreneur Parole. It's not a visa, it's not a status, it's parole. You've probably heard of the parole for refugees, for example, currently for refugees from Ukraine, from Venezuela, from Haiti. There is parole program where the sponsors can bring, relatives, family members, or friends, acquaintances, or anybody into the US from those countries because of the crisis there. So in the case of Ukraine, because of the war. So this is similar to that, but obviously, it's not based on the war or crisis. It's based on the fact that we have somebody who is started, who owns a startup, who invested money, who created this business in the US. They created jobs. Maybe they don't quite qualify for EB5, or even if they do, as I said, EB5 takes significant amount of time, and maybe their country doesn't have the E2 investment visa treaty with the United States. So for them to be able to quickly come into the US and manage their startup, there is this parole program. It allows them to enter the US for the purpose of managing business, and they can come to the US and live here and manage their business. But they're not going to be able to change their status in the US because parole is not a status. It's basically temporary permission to be in the US. The requirements are that you have to have a startup, it has to start from scratch, and you have to have invested, I believe, 250,000 as a minimum for the international entrepreneur parole. Okay, so to sum this up again is, you don't have to be in the US to create an own business. You don't have to have a work permit. You can be, for example, on a student visa and you can own a business. You cannot work for it, but you can own it, and we can help you with creating a business. The business immigrations into the US, number one, you have E2 investor visa, which is much easier to get. It's based on the treaty between the United States and your country, and you can look up the list of the countries, E2 treaty countries below, and if you find, then you may be a good candidate for E2. So E2 visa, it's very beneficial and easier to get. And then EB5, which requires substantial amount of investment. Usually, as I said, it's 1 million. In some target areas, it can be 500,000. And then L1 for the intercompany transferees of business entities that have affiliates in two different countries, meaning the United States and another country, where they're transferring employee into the United States. So those are the principal methods of immigrating into the US through ownership of a business and opening a business, creating a business in the United States. If you are interested in any of those, please contact us. There's going to be information in the links below. The links will be in the comments below for scheduling consultation with our office. And as I said, please do like this video and subscribe to our channel to get informed about the future live sessions. Now I will answer as many questions as I can. There are lots of questions posted in chat section. If you have any questions, you can post here. I will try to answer as much as I can. And even after that, if there are questions, you can comment, and we will do our best to answer your questions in the comments afterwards. Okay, so the first question is, what is business structure in USA? That's a very vague question. I mean, there are different business structures in the USA. So there can be limited liability companies, which is the most popular business structure in the US, LLC, and there are, obviously there are corporations. There is S corporation, which is, the differences for tax purposes between C Corp and S Corp. Then, there are partnerships, there are sole proprietorship, and some others. But for the purposes of immigration, you should know the principal business structures that would be applicable to you if you're a foreign citizen and wanting to start a business in the US. That would be most likely either LLC, limited liability company, or a corporation, C corporation. Can I stay in the USA? It's Irish accent. Can I stay in the USA? Can I stay in the USA if I start a business? Yes, I mean, well, depends. So as I explained, there are these ways of immigrating into the US through business investment, business creation, starting a business. And as long as you qualify under one of those, then you can stay in the US. Or you can come to the United States. Now, if you're already in the US, it depends on your current status, whether you can change it or not, whether it's a good idea at all to change your status in the US versus going through the consulate. A lot of people don't understand this. The difference is if you're in the US and changing your status, for example, to E2 investor visa, right, investor status, then once you leave the US, you will still have to go through the consulate anyways to get a visa stamp, because status in the United States only allows you to stay in the US. It doesn't allow you to enter the United States. Visa in the passport is a different concept. The visa allows you to enter the US. So there is status, which is permission to stay lawfully in status in the US, and there is visa, which is something in your passport to enter the US. So if you're applying for an E2 status and you change your status successfully in the US, and you leave the US one day and you go to and you want to return, you have to go to the consulate and get a visa anyways. So if you don't change your status, but get a visa from consulate, you would be killing two birds with one stone. You would get your visa stamp in the passport, and you would get the status in the US upon your entry into the US. So a lot of times, it doesn't make sense to change status. It may be better to get E2 through consulate. But in some other cases, if you think that the consulate is not going to give it to you, then, or you don't want to be risking, being left out of the U.S. because the consulate, for one or another reason, may not approve, then it may be, better to change status. That often happens in the context of changing status, for example, from a visitor B2 visa status to student status. Many people end up applying in the U.S. because the consulates are so inconsistent and often unfair in denying student visas. So that's why many of the students are motivated to file for their change of status in the US, and that backlogs the system. And the consulates are then dumbfounded why this person never came to apply for a visa here. Well, that's because you were inconsistent, using unlimited power to deny visas, and that's what consular officers have. So the consular officers, in the context of non-immigrant visas such as B1, B2 visitor visa, or a student visa, or a J1 exchange visitor visa, in the context of those visas, consular officers have unlimited and unchecked power. And that's why, quite often we hear people complaining that he didn't give it to me because he didn't like me, or he didn't, or he was in a bad mood, or, the consular officer was unfair. And that happens, unfortunately, because there are no checks. Now, the good news is for the E2 visa, you don't have to demonstrate close ties to your home country. So if you're applying for an E2 investor visa at the consulate, you do not have to demonstrate that you have a house, you have commitments, you will go back to your home country. You don't have to show that. So, and that's specifically actually in the statute, in the law, which says that. So differently from F1 student or from B1, B2 visas, E2 visas are easier approved at the consulates. And same with L1, obviously. Okay, what are the four main types of businesses? What is the American way of doing business? So I don't understand the question about four main types of businesses. If you mean, partnership, sole proprietorship, corporation, and LLC, those are the types of business entities in the US. But you don't have to think about these four types of businesses. Every business and every plan has its own specifics. So a corporation may be suitable, or LLC, but those two, LLC and corporation, are the main ones that you would be dealing with if you are planning to invest in the US and create a business in the US. Most likely you will end up either with LLC or corporation, because for tax purposes and generally, partnership is not a good idea for foreign owners to create from the beginning. What is the American way of doing business? That's a vague question also, unfortunately, but I'll tell you this. The American way of doing business is different than ways of doing business in many other countries. Well, I would say maybe the American way is close to it's, you can maybe put it under one umbrella of Western way of doing business versus Eastern way of doing business, or, depending on the countries where people come from. Well, the reason I say that I deal with immigrants, I've been doing this as immigration lawyer for more than 16 years. And I've, met thousands of immigrants, and many of them, maybe hundreds of them, were business owners and successful entrepreneurs in their countries. And sometimes they come to the United States with their preconceived notions of how to do business, and pretty, engraved ideas that this is how this business should be done, because based on, their experiences in their countries. And then they come here into the US, and then they face these difficulties, and they realize that, they may have been someone there, but there's no one here. They have to start from scratch. They have to learn, or they start ramming the idea of business in the US head on, and then they end with nowhere, and then they start from scratch. They kind of get demoralized, and then discouraged from doing what they were thinking to do in the United States. Don't be one of those. My recommendation is to plan ahead, to learn about the business culture in the US, to take courses, take classes, don't be shy to learn, to be a student again. Even if you were a great businessman, great entrepreneur in your country, start here from scratch and do it respectfully, respecting the system. That way, and by respect, what I mean is respect the challenge. So respect that the business, doing business and the way things are done, in another country is different from your country. I mean, it doesn't mean that it's better. I'm not claiming that United States is better than anybody else, but everybody else. But it's just different. So if you're coming here, if we're talking about the American dream, then we're talking about the United States, and that's why you have to learn the business culture and doing business in the United States before you actually start storming it and taking action on it. Now, I don't want to delay anybody. I don't want to tell you that you cannot do it. There are many successful businessmen from all over the world who came to the US and achieved their American dream in a very short and easy way. But not everybody is as lucky. So plan ahead, learn, and approach it respectfully, and try to assimilate to business culture in the United States. And that's what I think is the American way of doing business. How long to wait U visa to get approval? So if you have a U visa is a visa for victims of criminal activities in the United States. And if somebody who was a victim of certain crimes, not all of the crimes, they can get a certification from the police or law enforcement or even from a judge that they cooperated to to reveal or to convict that individual, whoever committed the crime. Then those individuals, immigrants in the US, can get U visa. The benefit of U visa is that anybody can qualify, even if you entered the United States unlawfully, even if you are unlawfully present in the US, have no status, but you were a victim of crime, then you can qualify for U visa. And the reason, the reasoning behind the U visa is to make sure that, whether you are lawfully in the US or not, that you're not taken advantage of by criminals who commit crimes and hope that you as an immigrant will be scared to report it. So that's why the United States gives you the U visa. Now, the U visa approval, I think it takes about close to 1 year. And then 3 years later, you can apply for permanent residency in the United States as long as you maintained your U visa and you were present in the US. Okay, the next question. Hello, sir. How long does it take to get interview notice after getting SSN? SSN has nothing to do with your interview notice, and you don't get SSN from immigration. You get it from Social Security Administration. What you got is a work permit. Now, it doesn't, the date when you get your work permit doesn't relate to the date when you will get your interview. Currently, the USCIS tries to avoid having scheduling interviews, and they try to waive interviews as much as they can. So, for example, in a marriage-based case, if you file everything correctly and everything is done and you provide sufficient bona fides of your marriage and your medical examination report, they will not schedule an interview. And even if you did not do those things, they will send a request for evidence to avoid having scheduling an interview. And the problem is, though, request for evidence will delay the process. So to answer your question, nobody knows. The Social Security number is something you get once you get your work permit. Your work permit is something you get while you're waiting for the green card, for the adjustment of status process. But those two processes are not related in terms of timeline. So in the past, the work permit, aka SSN, was something you would get within 2-3 months after filing. Now it takes about 6-8 months. And in the past, the green card process was also taking sometimes about 3. So there were some good old days about, I don't know, maybe 7 years ago, 10 years ago. So most of it was pre-Trump, when naturalizations and work permits were taking about 3 months. Okay, next question. Question is, my green card is pending. Can I apply for travel document and travel outside the country and come back without facing issues? Yes, as long as you have green card pending, as long as you have adjustment of status pending, you can apply for a travel document. The purpose of travel document is to allow you to travel outside of the US and return into the US. Now, the last part of your question, which says without facing issues, is something that you need to address specifically consulting with a lawyer one-on-one. You don't have to do it with me. You can hire another lawyer. You can talk to them, but make sure you get a thorough can be online or telephone, but individual consultation, because for everyone, it's different issues that they may face. For example, let me give you an example. If you have been granted asylum and you now you're applying for a travel document, but you don't have your green card yet because you have to wait for 1 year before you apply, and it may take another year for you to get your green card. If you get your travel document before you get your green card, and you'll use that travel document to depart the United States, there is a chance you may face issues. You may not be able to come back if you have stayed in the United States unlawfully for 6 months or more before you filed asylum. Even if you filed asylum on time before your status expired or within the first 6 months after the expiration of your previous status, you would still accrue 6 months unlawful presence if you worked without authorization, which many people understandably do after filing for asylum. So you see how many twists and turns and how many nuances there. That might be your case. So for me to tell you, yes, you can go without issues, that would be throwing you under the bus and risking your life, your future, by telling you yes. If I tell you no, maybe you don't have these issues, then you can travel. So instead of relying on this, just the forum answers or in this live video, you should consult individually with a lawyer. Okay, do you have a circuit court or BIA case that supports the idea that political opposition, opinion, asylum claims as it relates to refusal to serve in the military that can be cited? I do, but I don't have it handy. I cannot remember all these cases from my memory, but you can also look it up online. There is plenty of resources that shows all those BIA cases and circuit court cases supporting these, one way or another, either supporting the asylum claim that you're making or the basis, and some may not. Okay, can you assist me relocate to the US via tourist visa? I am from Nigeria. We do offer a tourist visitor visa assistance. What we do is we fill out the forms for you. There's nothing complicated. It's a biographical form, DS-160, but our law firm does fill that out, and then we help you identify any documents showing commitments, proving that you will return to your country, in this case to Nigeria, and then we work with you to prepare letters and then affidavits, financial support documents showing that you have someone in the US. If you do, you want to visit them or what you will do, and then we prepare you for the interview. So those are the services we provide to assist those who would like to receive visitor visa and come to the US. If you face some kind of challenges in terms of inadmissibility issues and so on, then we can also apply for a waiver of those inadmissibility basis. But if you're planning to relocate to the US, as this question asks, then we cannot help you, because visitor visa is not for relocating to the US. Visitor visa is a tourist visa, is to be, as the name suggests, either to visit or to be a tourist in the USA. So no law firm is allowed, and we don't. And unfortunately, I know some do. No law firm can help you to mislead or misrepresent information to the consulate and to apply for a visitor or tourist visa, knowing that your plan is to relocate and permanently remain in the United States. I know it's challenging, and I know sometimes we have clients consulting with us about asylum cases while they're abroad, and they're talking about getting a visitor visa so they can come to the US and apply for asylum, because you have to, right? You either have to arrive at the border to apply for asylum, or you somehow have to be physically present in the United States. So the question is sometimes, can I get a visitor visa and come to the US and apply for asylum? The answer is yes, you can apply for asylum if you do those things, but I cannot tell you that it's lawful to apply for a visitor visa, or I cannot help you with getting a visitor visa, knowing that you will stay here. If you do it because of fear and danger to your or your family's, safety or freedom in your country, if you mislead and you do those things and you somehow end up in the US and apply for asylum, that is not going to bar you from asylum, because it's considered that for the safety, for one's life and freedom, people can do those things. It's not it's not approved of, it's not encouraged, but that's not going to be basis of denial of your asylum. Okay, so next question is, which business is best for E2 visa? Any business, any type of business that is active business. So the difference is, as I explained, it has to be active and at-risk business. It cannot be a passive business, and it cannot be a temporary business. So for example, you cannot have a construction business that you're planning to buy a house, repair it, and sell it, and the investment in that house is not going to count because the real estate itself is a passive. Now, if you are going to have a truck, you have crew, you have equipment, you're going to have a construction team, and as part of your plan, you're going to be buying houses and renovating and flipping, that can qualify for E2 because you have employees, because you have progressive, plans of growing, and house is basically your inventory versus just owning a house and renting it out or flipping, one-time deal. That's not going to give you E2 visa. But any other type of business, we got E2s for, auto dealerships, we got E2s for grocery stores, convenience stores, gas station, marketing company, IT company, many IT companies, software companies, a sports company. So it could be anything, as I said, a pizza store, restaurants. We got a lot of E2s for restaurant owners and restaurant businesses. So it could be any business that is active and a real business. Would a laundromat or removals company with the intention of expanding be considered as an active business? Yes, it is. So laundromat, meaning the place where people do laundries, that type of business, a barber shop, a beauty salon. We didn't do laundromat before, but I've done barbershop and a beauty salon in the past. So all of that is considered as active business. Question: how about a situation where I'm a painting business owner? I'm growing as a company. Is that something that would work for a visa? Yes, it would work. So if this is a painting business and you have, staff, you have 1 or 2 employees, and you have invested sufficient capital into the business, or you can inject it now and buy, better inventory, do marketing, spend it for marketing and so on, then you can qualify, as long as, as I said, it's a real business, it will create jobs. Then at least that's what your plan is, then you can qualify for E2. Okay, can I apply I-130 while my I-730 is still pending? My wife got her green card. No, so I-730 is asylee petition for relatives. So for example, if you applied for asylum in the United States and your spouse was not in the US or was in some other kind of status and you got asylum, but they didn't go through the process with you and didn't get asylum grant together with you, then you can petition for your spouse and for your children by filing form I-730. The question is, can that spouse also file? I'm sorry, I confused. The question is about I-130. And I said, no, yeah, you may be able to file I-130. So the question is, if that spouse filed I-730, can that spouse who got her asylum can also file for I-130, okay? So I thought they're asking I-485, adjustment of status, which is the answer is no. But I-130, yes. So if your spouse also got her green card, so they had asylum and they got green card. Now the issue is though, I-730 is still pending. So as long as I-730 was filed within the last 2 years, then you can have that pending, and your wife who has a green card can also file I-130, and that's a different petition. So whichever comes first. So the answer to your question is that yes, your wife can file I-130 as well for you, while the I-730 is pending. Whichever comes first you can use, but generally I advise using I-730 because it gives you asylum status, and then you get to get a travel permit, travel document, which will substitute your country's passport. If you're not interested in that, then maybe I-130 would be a better option. But the I-130 will take another 2 years or so. So you'll probably get your I-730 approved much faster and earlier than I-130. So you may be wasting, filing fees if you apply for also I-130. Okay, prosecutorial discretion. PD still exists to request joint motion to reopen an old removal order based on an approved I-730. Yes, it does. It does exist, and you or your lawyer can file prosecutorial discretion request. The Office of the Principal Legal Advisor for Immigration and Customs Enforcement, they have their specific offices. They have their specific email addresses for prosecutorial discretion. If you Google PD, prosecutorial discretion, and the name of the court where you had your removal order, you will find it. And as part of that, they are often willing now to reopen the case, old removal order, terminate the case so that you can remain in the U.S. and then maybe qualify for permanent residency based on your asylum status. Okay, so the next question. I was granted asylum last month. I'm married. My husband was in my application. He is filing I-730, but he was deported from the border 4 years ago and re-enter. Is there any waiver for him? There may be waiver. He may be, so if he was deported and then re-entered, he may have a permanent bar of admissibility. This is a very fact-intensive question, which is very specific. You don't want to rely on a quick answer in the live stream or forum. You want to consult with the attorney. Okay, get a lawyer, talk to them, have a consultation, because there are many questions. For me to be able to answer this question, I will need to ask you many questions. So you can either contact us and have a consultation with me or with any other qualified immigration attorney. All right, last question. The USCIS adjudicates 730 application who has an old removal orders. My own 730 is pending for 25 months. So this is a third question from the same person, but I don't mind. Can I file mandamus action? Yeah, you may be able to file mandamus action, but the USCIS, will they adjudicate I-730? You have removal. What is the basis of that removal order? Your I-730 is pending for 20. I mean, that's the time when you need to consult with the lawyer. Again, this is very case-specific question, very fact-intensive. You should consult with the lawyer. About your specific case, there are many questions for me to ask you before I can answer this question. I received my asylum approval notice from the immigration judge through email. How long will it take before I receive the notice by mail? So there is no notice by mail usually. Usually they do online. So if you have been filing or your lawyer has been filing your documents online, so your asylum approval may be a notice filed through what's called ECAS, through online portal. That's probably what happened, and that's why you got the email. But why are you even interested in getting it by mail? It's just mail is going to be a copy of the same thing. There is no such a thing as original notice anymore. So everything is a copy. So mail is just going to be, you don't have to wait for it. You don't have to waste your time. So if you got approval from the judge, your grant for asylum, the next step for you is to contact the USCIS to schedule an info pass appointment where you're going to go, and they will give you your new I-94 forms showing that you are asylee. So you have to do it at the local USCIS office, but to do so, you need to contact the USCIS by calling 1-800 number. The 1-800 number, the easiest way to call it is if you call it between like 8 a.m., 8:30, close to 9. So anywhere between that time, because you will have least amount of hold. And when you call them, the automated service will answer. The first thing you should tell them is that you are calling about InfoPass appointment. Then they will transfer you to the agent, and you'll explain to the agent that you got grant of asylum. You need to get your I-94, and they'll schedule an InfoPass appointment at the local office, or they may take your number and call you to schedule it down the road. May take a couple of weeks or so to get that scheduled, but eventually you will get your I-94s, and that's what matters when you get your asylum approved, is to get that I-94. Again, folks, please post your questions. I still have time. I will answer as many questions as I can. Please also like and subscribe to our channel. In any time remaining after the questions or between the questions, I will come back to business immigration and tell you a little bit more about the commonly or frequently asked questions or challenges that people have. Okay. Right. Asked a bunch of questions since chat was not so busy. Okay. Also, can I work with approved I-730, even an old removal order? So if you have 730 approved, then you are in asylum status, depending on the old removal order, whether it is still valid or if it's been reinstated. There was a question about the re-entering. That can change the situation. Okay. Okay, thank you very much. Okay, good. So going back to business, and I see that we have live viewers, but there are not many more questions in chat. Maybe I was able to answer everybody's questions. If you do have a question, please post it, and I will answer as many as I can. But we were talking previously about business immigration through business ownership in the US, and I want to reiterate that you do not have to be physically in the US or have a work permit in the US to own a business in the US. So you can own and create a business, and that's where there is a lot of misunderstanding. There is a difference between working for the business and owning a business. Everybody can own business. You don't even have to be in the US. But to work for your business, even your own business, you have to have a work permit. You have to have employment authorization to be able to employ. Now, how can you get that work permit to work for your business? Usually it's not the work permit, but it's a visa, a type of visa that you can get, or your permanent residency based on that business. And those are the categories that we discussed, which are your E2 investment-based visa for small businesses. You would need to spend around 75,000 or more. Typically, we say 100 or more for a business, but that's for a small business. Any type of business would qualify as long as it's an active business. Then there is L1 for intracompany transferees for businesses that exist abroad and they want to open an affiliate business here in the US, then that can work. Or EB5, which is investment of 1 million or more, or 500,000 in certain areas, target areas, but you need to have a business which will create 10 US jobs. And those are the ways of immigrating into the United States through business ownership. There is also an immigrant international entrepreneur program, where this is a parole program where you can get a parole to be able to enter the US and work in the US and develop your business if you have a startup and you invested 250,000 or more into your startup. All right, the next question is, do you know how long a fiancé visa takes from filing? American bride, African future husband. So the fiancé visa is if your fiancé is abroad. So that's the only time you would have apply for a fiancé, not for someone who's in the US. But if your fiancé is abroad, located abroad, then the fiancé visa process consists of 2 stages. Well, 3 stages eventually, but the first stage is to do the fiancé visa, is to file a petition with the USCIS. Then once that's granted, that's approved, then the case goes to the State Department, to the consular section, where the consulate in the country of your fiancé will schedule an interview. So the process between the filing and the time your fiancé will get a visa is typically around 1 year or more. Used to be shorter. Sometimes there were times when it was 6-7 months. During the pandemic, it was significantly delayed. Now, the fiancé visa will allow your fiancé to get a 6 months visa to enter the US, and you will have 90 days to get married and to file adjustment of status for your fiancé. So after their entry into the US. But you cannot marry during the wait time. Now, during the pandemic, the fiancé visas got significantly delayed. We had some fiancé visa processes that have been taken more than 2 years because of the delays, first under the Trump administration due to chaos in the processing of these petitions and consular processing, and then eventually the pandemic made it much worse. So nowadays, we typically don't recommend fiancé visa, we recommend spousal visa. So if that's possible, it may be easier and better to get married with your fiancé and sponsor him or her through the spousal visa process, which consists of 3 stages. One is you file the petition in the US. Second is once the petition with the USCIS is approved, they transfer the case to the State Department and National Visa Center, asks for additional forms and documents. That's the second stage. And the third stage is the green card, is a permanent residency interview at the consulate. It's called immigrant visa, technical term for it, but basically means that if you pass that interview and get that visa, you become a permanent resident once you enter the US. So those are the 3 stages, and it takes about 1 year, 1.5, 12 to 18 months altogether. But it's a more secure way and better way of bringing your spouse. If you have made up your mind, you can get to get married, and if you can go and travel there to their country to get married, or you can get married anywhere else in the world if you would like to. That would be better than fiancé. But to answer your question briefly, fiancé visa about 1.5 years or so, spousal visa about 1.5 years, 12 to 18 months. But the benefit of spousal is that you have higher priority, and you don't have to do anything else after they enter the US. Where in fiancé visa case, you have to file for it. They have to file for adjustment of status in the US. Okay. I entered with a valid visa and my asylum. Okay, very good. Denied because my asylum denied because judge said I did not persecute enough to get an asylum. No fraud, no criminal, etc. Okay, good. So that helps that you were not, found to have filed a frivolous asylum application. Okay, the next question is about the humanitarian parole for Nicaraguan. I sponsor my sister-in-law and is here in USA, but she does not have all medical tests demanded by USCIS. Won't do it now. Humanitarian parole, I don't think that requires a medical test. What do you mean? If you mean the COVID test, COVID vaccinations, then yeah, but I just don't understand. So, and if you did humanitarian parole for your sister and she's already here, then what are your concerns? I just don't understand. I don't see any concern about that. Okay, I think this is end of the questions at this time in chat section. Again, it was a pleasure explaining you about the different ways of immigrating into the United States through business ownership, how you can own a business or create a business in the US. If you have any questions, please contact us. Our contact information is going to be below. And please, again, like this video. I see currently there are much more viewers than the likes. Please press like. That will greatly appreciate that. And please subscribe to our channel to be informed about next videos. But let me answer the last question. I just got this. I got my I-130 approved by marriage and applied for PD in court in November in Ohio. So how long will it take to get it approved? The Office of Principal Legal Advisors, they review meaning the government attorneys, they review those prosecutorial discretions in chaotic order. But the closer you are to your individual hearing or master hearing, the better it is. If you have master hearing coming up, it will be easier to do it at the master hearing and you've already filed the PD. Or, if you're close to individual hearing, then there will be a government attorney assigned to the case. Or your lawyer can contact OPLA, meaning the government attorney office, Office of the Principal Legal Advisor for ICE, and get them, kind of push on them, talk to their duty attorney, and get them to take action on that prosecutorial discretion. So that might be easier option. All right. Well, thank you so much again for joining us and for viewing this video. Please subscribe to our channel, press like, and put your comments in the comment section. Thank you very much. Bye-bye.